What every ERISA policy holder or plan beneficiary needs to know about the two most important protections provided to them under ERISA. Hey, I'm National ERISA Disability Attorney Nancy Cavey, and in this two-part series, I'm going to talk about the two most important protections provided under ERISA. The first is the ERISA fiduciary standards and duties that are owed to you, and second is the full and fair review requirements. Now, let's talk about protection number one. The ERISA fiduciary standards are very important because the administrator or the carrier normally will wear two hats. The first hat is the hat that they wear when they decide your entitlement to benefits or interpret the terms of the policy. The second is the fact that they pay the benefits. Now, obviously, if they make a decision to pay, that's going to ultimately impact the profits. And we all know that disability carriers and plans are all about profit. So there is this inherent conflict of interest, and this is why the ERISA statute imposes this fiduciary duty on the plan administrators or the carriers. So what is the fiduciary standard? Well, number one is sole best interest, and number two is prudence. Let me talk a little bit about each. Under the sole best interest standard, the administrator has to discharge its duty solely in the interest of participants and beneficiaries, and for the exclusive purpose of providing benefits to participants and their beneficiaries. Now that sounds simple, but in practice, it's anything but. Number two is prudence. Administrators are required to discharge their duties with the same skill, diligence as a prudent man would have under the same circumstances, and they have to administer their obligations in accordance with the plan terms. So those are the written documents that will govern your case. So you need to understand these very two important fiduciary standards, because it is very common that disability carriers or plan administrators violate these fiduciary standards. And these are grounds for an appeal if your claim has wrongfully been denied or benefits have been terminated. If you have any questions about your rights to your ERISA benefits, or your benefits have been wrongly denied or terminated, call me today at 727-894-3188 for a complimentary consultation. You're only going to have 180 days in which to file an appeal, and that appeal is the trial of your case. You may only have one level of appeal, so you don't want to screw this up. Call me today at 727-894-3188 for a complimentary consultation. I can help you regardless of where you live in the United States, regardless of the nature of your disabling medical condition, and regardless of who that disability carrier or plan might be. 727-894-3188.